judgment from a court unless there are procedural issues, and those are hard to do. So my take on this would be that if you are served with a demand for arbitration, get it in the mail, don't ignore it. You lose your right to object to the process. Hey, wait a minute, I didn't actually click the little box that said I agree to arbitration. You lose your right to object to it. You lose your right to participate in the selection of the arbitrator or object to arbitrators, okay? And that's, I'm sure he will talk about, that's the biggest thing. I, as a judge, have to file ethics filings and financial statements and all this so that you can check and make sure I'm fair and I'm not biased and whatever. Arbitrators don't have to do all of that. And that is a big concern. And very few arbitrators have been judges. So, which isn't bad in some regards. In a complex construction matter, having an engineer is probably more useful than necessarily having a judge, though I know quite a bit about engineering from, having learned over the years. But it also means that you may get an arbitrator that then makes a decision without your input on evidence, your input on or objecting to their evidence, and then when you're being sued in court to finalize the award and make it a judgment, as a court, as a judge, I can't do much. What else is there? Yeah, and I'll just point out, and I'm sure Richard will mention it in a minute, there are some of the consumer arbitration companies that were doing like credit card debts. I think several of them have been shut down, not all of them. But they had a phenomenal rate of awards in favor of the company, like 95% plus, okay? But here's what's even a bigger concern to me, because most of the time on credit card debts, the person will say, I owe it. I just don't owe that much, or I don't have it right now, or whatever, but they'll say, I owe it. The problem with them is, one of the consumer ones, they were requiring some of the arbitrators to do what, like 10 decisions an hour? 12 decisions an hour, pre-filled in. So how much time is that person actually taking to look at the documentation of they're saying you owe this, but how much was paid? And so A, they're making 12 decisions an hour, which means 5 minutes if you're lucky. B, they're getting paid effectively by the hour by the company that's then asking them to award in their favor, which means their entire salary is based on them benefiting that company. So your arbitrator selection is a huge, huge, big deal. And part of the reason, real quick, my last war story is, the reason I know this is I had an arbitration award, 10 plus years ago now, over a coal-fired electric plant out like in Cleburne. It was a $125 million arbitration award. And I vacated it on the basis that one of the arbitrators had links back to the attorneys who had hired him as an arbitrator, had selected him as the arbitrator for that case. And he was soliciting business from their law firm, and they were leading him on at the time, and they didn't disclose any of that information. And I'll tell you, it went all the way up to the Texas Supreme Court, and the Texas Supreme Court affirmed my decision, which is we vacated it, and they had to start the whole process over again. So this isn't just things that happen on a micro scale. They happen on a big scale, too. But just be aware that the selection of the arbitrator and making sure that they follow the process and that you've got a fair process is absolutely crucial in arbitration. So please, like I said, my takeaway as a judge is don't ignore it. If you get a demand for arbitration, don't ignore it. Okay? Any questions? Yes, sir.
Thank you, Judge. So I have some simple questions, but from the legal system perspective.
Sure.
So if it sounds like you guys are describing it, and thank you for the education, all of these companies taking advantage of consumers, and of course I don't go through things and I just click.
Right. And even if you see it, you don't necessarily know what it means.
Right. And I don't even know what's my alternative.
Right.
If I don't click, I can't buy this.
Right.
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 So why is the legal system allowing this to happen?
He can explain it better, but I'll give you a hint. Arbitration goes back to Caesar and before. Because if you're from Rome and you're doing business from somebody in Cairo, are you going to trust Okay. Are you going to trust a judge in Cairo, and is he going to trust a judge in Rome? Okay. So arbitration was originally as a business, a way of settling business disputes, especially where the parties had either nationality differences, or if I'm hiring you to manufacture my widgets that have trade secrets and very specific specifications, I don't want to disclose that in court. And as long as we have a contract, do it in arbitration, and it's kept quiet. For business disputes, that's not a bad thing, okay? Between sophisticated businesses, construction, I mean, between sophisticated business people, et cetera, there's a reason for it. Unfortunately, the law has developed such that arbitration is very hands-off for the court system. And unfortunately, businesses have figured that out. And he can go into the class action stuff, which I think is another horrible abuse of it, and remove your rights in many ways. And the court says, and the courts unfortunately have said it's okay. And I don't have, unfortunately, I apply the law. I don't get to make the law, and so that's why. I mean, there are valid, good reasons for arbitration. There really are. But I have a huge problem with arbitration of consumer disputes, of employment disputes, he'll talk about the massage envy case, which he's mentioned to me before, which is people being sexually abused at massage envy, and they're making them go to arbitration so that they can hide it, so it doesn't really hit the public that it's happening. Yeah, there's abuses in the system, but the legislature is going to have to take care of that. I, as a judge, cannot do that. Does that make sense? Any other questions? Yes, sir. I can barely hear you. He'll talk about that, and unfortunately, you're limited. Now, a lot of places, there a lot of times with written contracts and stuff, if you cross it out, a lot of times they either don't notice, or some, depending on the type of contract, they don't care. Not always. Unfortunately, it's becoming endemic in all contracts, in all consumer contracts, and if you want to buy that car, you may have to. But it's also being aware of your rights and what to do in case there is a problem and you do get forced into arbitration. But that's his area, not mine. How's that for an answer? Any other questions? Okay, well, I will turn it back over.
Oh, absolutely.
Thank you so much for being with us. Our Honorable Judge, Jannah, I'm proud to say they've been my neighbors for a long time. And they're still my neighbors, even though I moved from the neighborhood. She is running for election as a judge again. So please, I put some of these on the rotunda. If you're a registered Dallas County voter registered, please sign it for her petition to be reelected again. It will save her the fee. So I would really appreciate it if you can spread the word. And those are in the front, and there's some of them here. I'll circulate them among you. Thank you so much.
So, Omar, I'm going to call you back up.
All right, well, now I'd like to introduce Mr. Richard Faulkner of Faulkner ADR Law. Mr. Faulkner is one of the country's premier arbitration experts, and he's served in hundreds of local, international, and national and international arbitration cases, with some cases involving hundreds of millions of dollars. He's also the ABA's committee programs chairman and has been a judge in both Louisiana and Texas, and a commentator on U.S. Supreme Court arbitration cases for CPR Speaks. He's also been a recipient of the Oxford University's Course Directors Prize. So like all these titles you see, like that's not all of them. Like he's incredibly accomplished, incredibly smart, and I'd like y'all to give a warm welcome to Mr. Faulkner.
Thank you very much. I'm going to try to slip this over. The joys of being old and not being able to see as well as I once did. I know some of y'all in this group, and obviously Jamal just left. He and I go walking for exercise several times a week at 7 a.m. Anybody wishing to join us is welcome to come join us at Huffines Park. But let me go ahead and talk about arbitration. This is a field I've been active in for over 40 years. I've been a professor of alternative dispute resolution law. I used to have arbitration offices in Amman, Jordan, in Kuala Lumpur, in Singapore, as well as in London and here. And it's still an area that I'm very, very active in. Unfortunately, nowadays, arbitration is everywhere. It's not just for sophisticated parties, and that is a huge problem because every one of us in this room has signed dozens, if not hundreds, of arbitration agreements without even knowing or recognizing what is in there. What do I mean by that? Anyone who has used Amazon, and God knows with COVID, we've all ordered things on Amazon, hidden in Amazon's terms and conditions is an arbitration clause. If you go to work for Amazon, you can't work there unless you agree to arbitrate any disputes with them. No matter what happens to you, if you work for Amazon, you have to go to arbitration. You cannot go to court in front of a judge like Jannah. Worse yet, Texas has a unique aspect of its law in that we do not require companies to carry workers' compensation insurance. About half the companies in Texas do not. Why is that important? Because what they do is they impose arbitration on employees and injured workers and attempt to impose it even on the estates of dead workers who are killed at work so that they never have to go to a jury trial in front of judges like Jannah or anyone else. Consequently, in many places, if you go to seek employment or you are working at a business, you have agreed at least half the time in Texas to go to arbitration in the event you are injured or terminated for any reason that is illegal or you believe to be illegal under federal or state law. And very often that process is not very fair. Now, I like arbitration. I've been doing it for decades. But very often the companies I work with and represent have me or people like me negotiating these arbitration provisions. We know what we're doing. We're not going to get taken advantage of. But consumers and employees generally don't. You asked a question earlier about terms and conditions. What's in there? The answer is most of us don't know. In fact, a former federal appellate judge, Richard Posner, actually admitted that he did not read agreements that he signed and didn't know until later on that there were arbitration provisions in them. If sitting federal appellate judges don't know, the rest of us have got a bit of an issue with it. Now, why is this of concern to us besides consumers? There are a couple of y'all in this audience that have gray hair like me. Almost every nursing home in America requires people to agree to arbitrate for themselves and their loved ones in the event that anything bad happens in nursing homes. That was, for example, used to try to hide the case where a certain elderly lady was eaten alive by red ants at a nursing home in Fort Worth. Now, none of us would expect that something like that would be in a nursing home agreement. It's in almost every one in America. Very often in these agreements, if you look, you can find that there's an opt-out or a decline or a refusal provision. And so questions were asked, what can we do? Well, if you see one of those provisions, opt out. It may be a very onerous and difficult process, a la massage envy, but opt out. Say no. Cross it out. Say, I'm not doing that. Many merchants still want to make the sale. They want the transaction. So they will still do business with you without the arbitration provision. I personally, and I'm kind of blessed, my name is Richard Faulkner. It looks a heck of a lot like refused, and I write refused across those things all the time. I've never yet had anyone call me on it. and I've been doing that for about 30 years. What other areas might you find arbitration? Schools. Many of y'all may have heard of ITT, the no longer in existence infamous so-called training institute. They had to pay $300 million to the federal government to settle fraud charges because they were using arbitration provisions to hide how they defrauded students. Yeah, think about that, $300 million. They're not the only ones. I recently had a look at a U-Haul truck rental agreement. Anyone here use U-Haul? I sure have. Not terribly long ago, there was a rental of a U-Haul trailer and truck combination. Unfortunately, there are allegations that there were some problems with the truck and the trailer connection didn't work right. And the person who rented listed another gentleman as an authorized driver. Now, that guy didn't sign the agreement, didn't even know he was listed. Horrible accident, both of them were killed. U-Haul today is trying to force the estate of that dead man and his wife and his widow and children into arbitration so they don't have to go to the court system. Because the first driver who actually leased the vehicle listed him. Now, they could have listed the Easter Bunny. They could have listed, Julius Caesar. And according to U-Haul, the Easter Bunny and Julius Caesar would have to go to arbitration. That's the kind of thing that is happening more and more frequently to folks, and you don't even realize it. Now, Gina and others have talked about if you get mail and it looks like it's from an arbitration group, for God's sake, open it. Because there is no service of process. You will not get a sheriff coming out and handing you a citation to let you know what's going on. It looks like junk mail. So be aware of that, because you can end up finding that arbitration's been demanded against you and not have any idea. You've heard some comments about arbitrators. I sometimes joke, arbitrators look like me, old male, pale and stale. There is almost no one in any minority group and very few women who serve as arbitrators. When Jay-Z was involved in litigation that was sent to arbitration, he asked for any minority arbitrators. The American Arbitration Association couldn't find any in the entire United States. He sued them over it. The AAA responded and came up with 3 arbitrators that were minorities. One of them was a partner in the law firm representing Jay-Z's opponent. Doesn't that make you feel just warm all over to know that a lawyer on the other side is one of your 3 choices? That's the kind of shenanigan that has been going on in this field for the consumer arbitrations for decades. I've taught this area as a law professor. There's something called the repeat player effect, but basically we can all understand that if arbitrators are constantly paid by the businesses that force arbitration provisions, you as a consumer or as an employee, or God forbid, you representing the estate of someone, is not likely to get a fair shake there, because that arbitrator knows that if they vote against that company has a right to strike them in the future and is going to remove them. And for a long time here in Dallas, every AAA arbitrator who ruled for an injured person magically disappeared from the roster of potential arbitrators. Wonder how that might have happened. So one of the things here is that you need to pay serious attention to what is in these agreements. Don't agree to arbitration if you don't have to. Refuse, write refused, X through the box. If it has an opt-out provision, actually follow it. The other thing you can do is if you get a demand for arbitration, don't ever agree to any arbitrator proposed by the business. They are not there to help you. They are not there to treat you fairly. They are there to make sure that they get more business from that business. And we're not talking minor sums. Many of the arbitrators are paid between $300 and $700 an hour. It is very common in commercial arbitrations for the arbitrator fees to be $100,000 or more. So we're talking serious money, and the ability to continue to hear cases involving that business is a serious temptation for many, many people. In the case Jannah was referring to, Ponderosa Energy, I can assure you, having heard similar cases, that arbitrators' fees were probably in the neighborhood of $250,000. So, you know, consumer cases, those arbitrators tend to make about $1,500 to $2,500 per case. So think about it. Many of these businesses have 40, 50, 60 cases that they send to a particular arbitrator. You can do the math. I wouldn't trust somebody like that, and I suggest you shouldn't either. What else can you do about it? If you get an award that says that supposedly you participated in an arbitration, or you did and you lost, the time period for trying to vacate it, overturn it, you know, have it undone by a judge is 3 months in federal court or 90 days in Texas. It's jurisdictional. If you file suit to vacate on day 91, you're out of luck in a Texas court. If you file suit to vacate in the federal court and don't file suit and serve the suit through the U.S. Marshal within 3 months, you're out of luck. And serving things by the U.S. Marshal takes about 3 to 5 weeks. So in reality, you only have about 2 months to actually file a motion to vacate and try and undo any arbitration awards. The basis for undoing them is extraordinarily narrow. It's one of the smallest areas of opportunity known to the law. What else can you do? Well, Congress, for once, has actually done a little bit in the area, and the House of Representatives has repeatedly passed something called the Forced Arbitration Injustice Repeal Act, the FAIR Act. It keeps passing the House, it always dies in the U.S. Senate. So, if you don't like arbitration based on what you've heard or may have personally experienced, let your senators know. They do pay attention to voters. Last, if you have issues and you need help, please contact UNT School of Law. Omar and others are there to be able to help you. They have access to Professor Downs, to me, to other people, to Khalid Hamada and all. We've been chatting about trying to do maybe pop-up law clinics here and at some of the other masjids. So, you know, we're trying to make the law and law students and legal advice readily available. Feel free to ask. Some of y'all see me periodically. I literally go walking with Jamal 2 or 3 times a week. Depends upon what the weather's like and whether my wife and his make us both get up and go out there and walk. But you're welcome to join us. Ask questions. Now, with that, I'm going to open the floor. Does anybody have any questions about this? I'm glad to answer them. Yes, sir. You have a remedy that is so narrow as to be non-existent. I'll give you a perfect example. Some of y'all have heard of the Chinese telecom ZTE, okay? It is, in reality, a front for Chinese military intelligence. I was counsel in an international arbitration against them where the Texas company had won a contract for a telecom concession in the country of Liberia. ZTE stole it. They literally bribed anyone and everyone, and people from the Chinese embassy carried bags of cash to different Liberian officials until such time as they stole the contract. We brought an arbitration here. The American Arbitration Association was named. We had to go to them. The arbitrator blew it. 2 weeks later, ZTE pled guilty to obstruction of justice and lying to the FBI. I used that because what ZTE admitted to were some of the same things they'd done to our client. Trial court vacated. Went to the Court of Appeals. The rules are so narrow for overturning an arbitration award that wasn't within them. I took it to the U.S. Supreme Court. U.S. Supreme Court denied a petition for cert. It is almost impossible to vacate an arbitration award, even when you have people like me who do nothing but arbitration work trying to vacate it for you. Final and binding means exactly that. It is almost impossible. So do you have a technical right? Yes. We both have a right, if we can, to sprout wings and fly to the moon. I don't think any of us are going to do it. And that's about as likely as successfully vacating most arbitration awards. Any other questions, y'all? I'm glad to answer. Yes, sir. And then I'll come back to you. Sure. Yeah, it goes back even further than that, because in 464 BC, if you were a citizen of Athens and the leaders called on you to be an arbitrator and you refused, you lost your Athenian citizenship. Good question. Let me answer those. All you have to do is be 18 years old and not have a felony conviction. That's it. That is literally it. Now, yes.
In some specific technical fields, like as an engineering or petroleum or something, they will sometimes put in provisions that the arbitrators either A, cannot be lawyers,
Right.
or that they be lawyers, but they also have to have certain technical requirements or certain number of years of experience in a certain field. But no, that's the other thing is that's a big concern is they don't have to have any knowledge of that area or of the law.
And in consumer arbitrations, you very often find the people who know little or nothing and quite often are not lawyers. It is really frightening. That is something that many of us have huge problems with. If you're doing insurance reinsurance, I'm on the board of directors of an insurance company. Nobody's taking advantage of us when we negotiate arbitration provisions. Really, I'm looking at my counterpart on the other side of the table. For the average consumer, none of us generally are able to deal with those companies on equal terms. Companies like Massage Envy, 300 plus sexual assaults across America of women who have been assaulted at Massage Envy locations across the country, and they fight every time to force those ladies' complaints into arbitration to keep them secret. The only reason that came out was that a judge did not agree out in California, and the press got a hold of it, and it was reported in USA Today and in some other places, and that's how the word got out. Yes, sir. Yes, a good question. Arbitration is regarded as confidential, and you heard Jannah talk about the arbitration procedural rules. Virtually all of them require confidentiality and secrecy, so everything is hidden. Only the award generally may be filed. And if the award is one that says take nothing, or the claimant receives zero, like a consumer gets nothing, who's going to go to court over that? Nobody. If the company, on the other hand, loses $100 million, I assure you they're going to do something. Now, some companies flat out lie. And years ago, I was opposite one that did that, and they always told the people who owned the auto dealerships on the other side, we never lose. I beat them. Got a $500,000 award. They were supposed to pay on Tuesday by 5. They didn't. I filed suit in federal court attaching the award and demanding payment. They got really upset because I was violating the confidentiality provision. But said, curry me over a check. Next morning, I had a check in my office. They demanded I dismiss my motion to confirm. I did. I filed a motion to dismiss on the basis of full payment, and I attached a copy of the check. To say that I got an obscene phone call after that is an understatement, but the judge signed the order with the check attached, and there was nothing they could do about it. So yes, you can sometimes game it, but it's generally secret, and nobody knows what happens. Any other questions, y'all? Yes, sir. Each individual organization, they have their own criteria. For example, I sit for the International Chamber of Commerce in Paris as an arbitrator. I sit for the London Court of International Arbitration. They have different panels. I sit for the International Arbitration Center in New York, the Center for Public Resources. I do not sit for the American Arbitration Association. I've sued them too many times. JAMS has its own criteria, and National Arbitration Forum, the organization Jannah was talking about for consumers, had its own qualifications, and amongst its arbitrators were investors in the credit card companies and banks that sent all the credit card arbitrations to NAF. That's why they got sued by the Attorney General and shut down. Here.
So if you file something in court, there are, like I said before, there are circles in it. You file it in the district court and you know what the courts are. If arbitration agreements, we usually have a arbitral forum in them. So the big ones in Texas are American Arbitration Association, JAMS, which used to stand for Judicial
Arbitration and Mediation Association.
And there's a few more like that. And for example, JAMS used to be okay? To be on the JAMS panel, you had to have been a former judge, okay? They lived in that whatever. That was their niche speaking. American Arbitration Association, generally you have to be a lawyer and some other stuff. You have to
Maybe.
apply, and they have to approve who's on the panel, which is one reason there's no diversity. It's the same old white guy approving the same old white guy. I mean, not to be rude, that's
No, it's accurate.
that's a problem.
I used to be one of them.
Each administering agency appoints and has a panel of its own arbitrators. So the problem is, let's say I create Richard Arbitration Forum, and I put it in a whole bunch of contracts for buying cars, and I can require that every arbitrator be named Richard. Doesn't have to be a
Great idea, by the way.
doesn't have to know anything about auto dealerships or auto contracts or anything else. My rule could be that everybody on this panel has to be named Richard. Okay, you're stuck with it. If you agree to that arbitration clause and can't get out of it, then the way the courts look at it, unfortunately, and I disagree with this, is you agreed to it. You could have gone and found that it was Richard's arbitration and pulled their rules and found all of this. Most of us don't have time. I don't even have time. And I'm a judge and I'm a lawyer. I don't have time. But that's one of the ways that you're taking advantage of it. Each administering agency, which are private companies, remember, have their own criteria, their own, and it's not even like, here's our criteria, okay, you met it, you're on the panel. You have to apply and be approved. So there's a lot of ways to game the system in that too. So that is one of the real concerns, is that some of the consumer arbitration groups do not require them to be lawyers. They don't even require that they have any knowledge of the law necessarily. And that's why it's such a problem.
There's a construction arbitration group out of another part of the United States that approached me about possibly sitting. And the owner of that organization basically flat out said, look, if you rule against any of the companies that use our clauses, you'll be removed from the panel. And I suggested that something rude and said, I'm not on your panel because I refuse to be a prostitute. And, but he's got a list of dozens of people. And if you have a dispute and that organization is listed, good luck winning. Now, if you get that dispute with that organization, let me know. There are ways to sue them for that, but it's really hard. Yes, sir. Yes, by statute in Texas, you may bring a lawyer with you. Not all arbitrators, especially non-lawyers, will be very happy about that. You asked a really good question earlier. Why does the law allow this? This is a 1925 statute that was passed in the Calvin Coolidge administration and has every consumer protection you would expect of a 1925 statute. There aren't any. Big businesses figured this out in the early 1990s. Some of the businesses put some very aggressive clauses in agreements. There's a well-known case called Rent-A-Center versus Jackson that said that an arbitration agreement can even send to arbitration disputes over whether or not anybody has agreed to arbitrate or what they've agreed to arbitrate. I'm glad to see that the Supreme Court validated the drafting because I wrote it. It has turned into Frankenstein. It has given me more headaches in the last 20 years than I could ever keep track of. But these issues are being fought out literally as recently as Wednesday morning of this week. Arguments over these issues were raised in the Florida Supreme Court. I wrote a brief as an amicus friend of the court on behalf of the consumers, Mr. and Mrs. Doe, because Airbnb requires arbitration, and they took a vacation, used an Airbnb, and the owner of the place had it wired for video, and as their petition says, it recorded some private and intimate moments which we were then allegedly put on the internet. And Airbnb has fought for 4 years to force them into arbitration so that they cannot get a jury trial. And that matter was argued literally Wednesday morning. And frankly, I expect the Florida Supreme Court is going to uphold Airbnb because the presumption is when you click off on that click wrap contract and you put a checkbox next to terms and conditions, you're supposed to scroll through the 54 pages of legalese and find the blue hyperlink that then leads to the American Arbitration Association provisions, and then understand that in Rule 7, you have agreed that the arbitrator can determine his or her own jurisdiction and all issues of arbitrability. Good luck with that one. But these issues are literally coming up and being heard in the courts, and it's a matter of federal law, and state judges can do almost nothing about it. The federal courts are extremely aggressive in pushing arbitration, and I'll just tell you in part why. I've been a law professor. Many years ago, the credit card industry and the large banks wanted to use arbitration so they didn't have to go to court. They hired a law firm in New York, and that law firm put one of its best arbitration lawyers on it. He spent several months researching and then drafting. And the result was the arbitration provisions that are in every credit card company agreement and almost every bank agreement in America. And that gentleman left that law firm. He got a better job. Today we know him as Mr. Chief Justice of the United States, John Roberts. So he is grading as the Chief Justice of the United States the same clauses he drafted. If that sounds a little unfair, you probably have the same opinion of it that I do, but he's there, I'm not. And I will tell you, I've been in the U.S. Supreme Court on arbitration cases, and he is aggressive in enforcing arbitration. And so, you've got to watch out for yourself. And if any of y'all have questions you don't want to ask in the group, come catch me afterwards. Y'all sometimes see me around here, and Jamal always knows where to find me. Any other questions, y'all? Yes, sir. Yes, you can. You can do that. And in fact, where it's two companies that know what they're doing, it can oftentimes be a good idea. Let's face it, many times you don't need to spend the time in a jury trial. If you need technical expertise, if you have a need to protect secret medical information. Any of y'all sports fans here? Anybody know who Lance Armstrong is? Okay. You remember reading he was sanctioned $10 million for lying in arbitration? I was the chairman of that tribunal. I'm the one who did it. I don't get Christmas cards from Lance. Literally, when there are special needs, it's a good idea. I'm not anti-arbitration by any means. That's what I do. But against consumers and employees or the estates of employees killed on the job, it really was never designed for that. And from merchant to merchant, great. Merchants, business people are generally sophisticated. Yes.
And they admitted in retrospect it should have, because it took them a month to try the case to me. Because to be honest, I know nothing about natural gas processing. Okay? I mean, I'm literally going home and I told his college chemistry.
I was a physical organic chemist as an undergraduate.
Because it had a chapter on natural gas processing. This is towards the beginning of the case. But I knew nothing about it. And I was so confused by the contracts, because they're using terminology, you know, plant gas versus waste gas versus this. I don't know what that means. So that is a case between businesses that would have been great for arbitration. Some oil and gas lawyers who know what the heck they're talking about, that would have been great, and it would have been a lot faster versus them educating me. And I'll tell you, it was originally set as a jury trial, and the parties agreed to do it as we call a bench trial, where there's no jury, it's just me. That took a month, a full 4+ weeks of testimony. If we had to do it as a jury trial, okay, which just has stricter rules on evidence, the jury isn't allowed to ask questions, where I frequently would stop and look at their witness and go, excuse me, back up, can you repeat that, because I have no understanding of what you just said. It would have easily been a 2-month-long jury trial. Easily. I mean, and that's just what it is. But that's the kind of case that would have been perfect for arbitration, right? Because sophisticated businesses, I mean, these are like million-dollar, multi-million-dollar contracts over natural gas processing. That would have been perfect for arbitration. Sophisticated business people, they knew they were doing. Yeah, they would have been fine with it. Instead, they got to teach me oil and gas.
Any other questions, y'all? Yes, sir. Right. Click wrap contract. Mm-hmm. Very often, but I mean, if you don't want to do business with Amazon, find the alternative. And that's basically what many folks are left to do. And so, at least look, and if they give you an opt-out, exercise it.
Arbitration isn't necessarily a bad thing if you know your rights and you know what to do.
Mm-hmm.
And that's what a lot of my focus is awareness. Okay, you didn't know you had an agreement with one of your vendors that you're now forced to arbitration. Okay, you know not to be worried when you get that letter in the mail. You know that you need to participate in investigating the arbitrators and questioning whether or not they have links to the other law firm or that vendor, right? And that's the thing is, arbitration isn't necessarily bad. A lot of it's how it's being used. But it's being used on people that don't know, aren't aware, and don't know what to do. That's the thing.
For example, in your area, cyber insurance. Most folks have to have it. Do you know what's in your cyber insurance policy? Would you be surprised to find out that if you have a cyber insurance policy for $1 million and $1 or higher, there will be arbitration provisions? It gets better. The arbitrations are generally required to be held in London. 2 of the 3 arbitrators, because of the nationalities clause, cannot be American. The stated law of the contract will be New York, so you have a British, typically a Brit, and maybe a Kiwi or an Aussie, determining issues of New York law involving an American policyholder trying to obtain coverage. Do you think maybe it explains why they so often lose? And that's the type of thing that very often you have no idea it's there. Yes, sir, you had another question. That's correct. But if you at least get it and know what it is and file an answer, or you get somebody, maybe Omar or another person to help you, you can object to the forum. When Jannah was talking about procedures, you can object to going in front of national arbitration forums and say, you guys are just in the pocket of the other side. But you've got to make the objection or you waive it. You can object to John Doe as an arbitrator when Doe didn't tell you that he sat 500 times for XYZ company. But you have to make the objection. Yes. Mm-hmm.
I have a basis. Remember those really limited rules, like when you
Yep.
take something on? That's one of them. That the arbitrator was biased or prejudiced, meaning had an economic influence, whatever. That I can say take an arbitration award on. But you have to have participated in the process and made the objection. I personally don't find much benefit of any consumers from arbitration. Unfortunately, it happens. And if you want to buy a car, you may get stuck with arbitration.
AutoNation.
I will tell you, buying a house, if you buy a house,
Mm-hmm.
I promise you, in your title insurance, and in all those contracts, they almost always...
Homeowner's warranty.
Yeah.
It's hidden in the homeowner's warranty, which is mostly air. I've arbitrated those cases until I ruled for the consumer too many times and got stricken from the panel. There's almost nothing really there.
The point is, as a consumer, if you want to actually live in reality and not operate somewhere that has no electricity, they're in almost all the contracts. So unless you don't want to have a car, you don't want to have a credit card, you don't want to have a bank account, you don't want to buy anything, then you're going to get stuck with arbitration at some point. Theoretically, I mean, you're signing a clause. The whole thing is, what do you do if you know it's there? And we're trying to make you aware of some of the problems and some of the pitfalls, so you know not to ignore it, to ask for help, to read the rules, and to ask for advice. So you're going to get stuck with an arbitration clause.
And let your senators know. The House has already passed the FAIR Act again for about the 10th time. But let your senators know what you think of it, because they can and will do something. For example, sexual assaults have gotten to be such a problem in some workplace environments that there is now a bipartisan, the Democrats and the Republicans agreeing on something. There's a bipartisan bill currently in the Senate and in the House to eliminate arbitration for sexual assault claims. And that legislation is pending right now. Senator Graham and 2 other Republican senators are co-sponsoring it with the chairman of the Senate Judiciary Committee. So, there can be change, but only if you let your representatives and senators know. And by the way, both Senator Cornyn and Senator Cruz are on the Judiciary Committee, so they might find your views interesting. Any other questions, y'all? I'm going to hang around so y'all can keep asking me questions as long as you want. I know Jannah has other places to go, and Omar was probably wondering if I'm ever going to be quiet. So, Omar, why don't you come back up? Oh, you have a question. Uh-oh. And what's your question?
My question is, Mommy letting me go on the stage.
Sit underneath. That's your mother's. Your mother's the arbitrator of that one, not me. Thanks, y'all.
Thank you. So, if you think you have an arbitration issue that you would like to get looked at, the Community Lawyering Center at our school can offer some services. So I just wanted to have these numbers up so that y'all can contact them. Professor Downs is the mastermind behind the Community Lawyering Center, so she will take care of you if you need any kind of help. And that's pretty much it. Does anybody have any other questions? Well, thank y'all so much for attending.
Thank you very much for listening. Have a good day.
That's okay.
Have the best day you can. Thank you. Goodbye.
Is we want to come back if you'll have us. I mean, and I.
In 15 minutes, you are ready to.
As I said, part of our mission is to empower. To empower. We want people to have information because it's powerful. Know your rights.
Have a good day. UNT Dallas is all about good things that really did happen. And also responsibility and necessity. Have a good day.
Put that down right this minute.
And that is it. Mom, Angela Downs is going to say something.
Thank you. That's enough. Thank you.
You're welcome.
Thank you for coming. We appreciate it so much.
My name is Ashton.
Oh dear. All right, now that's
My name is Ashton. I'm 6 years old. I'm in first grade, and I'm 6 and a half.
very fascinated by the microphone. Thank you so much for coming.
Thank you, everyone, for coming.
We're delighted to be here.
Have a good day. Everybody, we will take a picture. Please go up to the stage. Everybody, Angela Downs is going to take a picture. Please come to Angela Downs. I need everybody to listen. Angela Downs is going to want to take you to have a picture with her.
Would you please?
Have a good night. You're welcome.
Thank you.
Have a good night, everyone. I got a cookie.
a child that has to be at baseball practice in
The first step would be
You're welcome
to
now.
arbitration.
Right, very common. But it's not the first step, it's the first and last step. They just don't know. And last.
So I'm just gonna run the mic.
Oh, sure. Oh,
They may not have it as a first step, but I think part of the agreement that arbitration would be the first to remedy any conflict. If you or if one of the parties, for instance, is receiving notice from a attorney or something like that, then we're going to sue you. Is that how it goes?
But if it's off. Let me put this first, otherwise Amin will kill